Draft version 1.
American Apologetics. A perusal of Dobbs v. Jackson. Leaked abortion case. Written and produced by Pacificatoris.
Partie
B. 1. Until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. 0. None. No state constitutional provision had recognized such a right. Until a few years before Roe was handed down, no federal or state court had recognized such a right. Nor had any scholarly treatise of which we are aware. And although law review articles are not reticent about advocating new rights, the earliest article proposing a constitutional right to abortion that has come to our attention was published only a few years before Roe. Not only was there no support for such a constitutional right until shortly before Roe, but abortion had long been a crime in every single state. At common law, abortion was criminal in at least some stages of pregnancy and was regarded as unlawful and could have very serious consequences at all stages. American law followed the common law until a wave of statutory restrictions in the 1800s expanded criminal liability for abortions. By the time of the adoption of the 14th Amendment, 3/4 of the states had made abortion a crime at any stage of pregnancy, and the remaining states would soon follow. Roe either ignored or misstated this history, and Casey declined to reconsider Roe's faulty historical analysis. It is therefore important to set the record straight. 2. We begin with the common law, under which abortion was a crime at least after quickening, i.e., the first felt movement of the fetus in the womb, which usually occurs between the 16th and 18th week of pregnancy. The eminent common law authorities, Blackstone, Koch, Hale, and the like, all describe abortion after quickening as criminal. Henry de Bracton's 13th century treatise explained that if a person has struck a pregnant woman, or has given her poison, whereby he has caused an abortion, if the fetus be already formed and animated, and particularly if it be animated, he commits homicide. H. Bracton, De Legibus et Consuetudinibus Anglii, 13th century treatise. Sir Edward Coke's 17th century treatise likewise asserted that abortion of a quick child was murder if the child be born alive, and a great misprision if the child dieth in her body. 3 Institutes of the Laws of England 5051, 1644. Misprision referred to some heinous offense under the degree of felony. 2 treatises by Sir Matthew Hale likewise described abortion of a quick child who died in the womb as a great crime and a great misprision. And writing near the time of the adoption of our Constitution, Blackstone explained that abortion of a quick child was by the ancient law homicide or manslaughter, citing Bracton, and at least a very heinous misdemeanor, citing Koch. English cases dating all the way back to the 13th century corroborate the treatise's statements that abortion was a crime. In 1732, for example, Eleanor Bears was convicted of destroying the fetus in the womb of another woman and thereby causing her to miscarry. For that crime and another misdemeanor, Bears was sentenced to 2 days in the pillory and 3 years imprisonment. Although a pre-quickening abortion was not itself considered homicide, it does not follow that abortion was permissible at common law, much less that abortion was a legal right. C.F. Washington v. Glucksberg, removal of common law's harsh sanctions did not represent an acceptance of suicide. Quite to the contrary, in the 1732 case mentioned above, the judge said of the charge of abortion, with no mention of quickening, that he had never met with a case so barbarous and unnatural. Similarly, an indictment from 1602, which did not distinguish between a pre-quickening and post-quickening abortion, described abortion as pernicious and against the peace of Our Lady the Queen, her crown and dignity. That the common law did not condone even pre-quickening abortions is confirmed by what one might call a proto-felony murder rule. Hale and Blackstone explained a way in which a pre-quickening abortion could rise to the level of a homicide. Hale wrote that if a physician gave a woman with child a potion to cause an abortion, and the woman died, it was murder because the potion was given unlawfully to destroy her child within her. As Blackstone explained, to be murder, a killing had to be done with malice aforethought, either express or implied. In the case of an abortionist, Blackstone wrote, the law will imply malice, for the same reason that it would imply malice if a person who intended to kill one person accidentally killed a different person. If one shoots at A and misses him, but kills B, this is murder, because of the previous felonious intent, which the law transfers from one to the other. The same is the case, where one lays poison for A, and B, against whom the prisoner had no malicious intent, takes it, and it kills him. This is likewise murder. So also, if one gives a woman with child a medicine to procure abortion, and it operates so violently as to kill the woman, this is murder in the person who gave it. Notably, Blackstone, like Hale, did not state that this proto-felony murder rule required that the woman be with quick child, only that she be with child. And it is revealing that Hale and Blackstone treated abortionists differently from other physicians or surgeons who caused the death of a patient without any intent of doing the patient any bodily hurt. These other physicians, even if unlicensed, would not be guilty of murder or manslaughter. But a physician performing an abortion would, precisely because his aim was an unlawful one. In sum, although common law authorities differed on the severity of punishment for abortions committed at different points in pregnancy, none endorsed the practice. Moreover, we are aware of no common law case or authority, and the parties have not pointed to any, that remotely suggests a positive right to procure an abortion at any stage of pregnancy. 2. In this country, the historical record is similar. The most important early American edition of Blackstone's commentaries, District of Columbia v. Heller, reported Blackstone's statement that abortion of a quick child was at least a heinous misdemeanor. 1 St. George Tucker, Blackstone's commentaries, 129-139, 1803, Tucker's Blackstone, and that edition also included Blackstone's discussion of the proto-felony murder rule. Manuals for justices of the peace printed in colonies in the 18th century typically restated the common law rule on abortion, and some manuals repeated Hale's and Blackstone's statements that anyone who prescribed medication unlawfully to destroy the child would be guilty of murder if the woman died. The few cases available from the early colonial period corroborate that abortion was a crime. In Maryland in 1652, for example, an indictment charged that a man murderously endeavored to destroy or murder the child by him begotten in the womb. Proprietary v. Mitchell, W. H. Brown, edition, 1891. And by the 19th century, courts frequently explained that the common law made abortion of a quick child a crime. 3. The original ground for drawing a distinction between pre- and post-quickening abortions is not entirely clear, but some have attributed the rule to the difficulty of proving that a pre-quickening fetus was alive. At that time, there were no scientific methods for detecting pregnancy in its early stages, and thus, as one court put it in 1872, until the period of quickening there is no evidence of life, and whatever may be said of the fetus, the law is fixed upon this period of gestation as the time when the child is endowed with life, because fetal movements are the first clearly marked and well-defined evidences of life. Evans v. People, 1872. In contemplation of law, life commences at the moment of quickening, at the moment when the embryo gives the first physical proof of life, no matter when it first received it. The Solicitor General offers a different explanation of the basis for the quickening rule, namely, that before quickening the common law did not regard a fetus as having a separate and independent existence, but the case on which the Solicitor General relies for this proposition also suggested that the criminal law's quickening rule was out of step with the treatment of prenatal life in other areas of law, noting that to many purposes, in reference to civil rights, an infant in uanter sa mir is regarded as a person in being. At any rate, the original ground for the quickening rule is of little importance for present purposes because the rule was abandoned in the 19th century. During that period, treatise writers and commentators criticized the quickening distinction as neither in accordance with the result of medical experience, nor with the principles of the common law. The Criminal Law of the United States, Section 1220, at 606, 4th Revision Edition 1857, see also J. B. Beck. Researches in Medicine and Medical Jurisprudence, 26-28, 2nd edition 1835, describing the quickening distinction as absurd and injurious. In 1803, the British Parliament made abortion a crime at all stages of pregnancy and authorized the imposition of severe punishment. One scholar has suggested that Parliament's decision may partly have been attributable to the medical man's concern that fetal life should be protected by the law at all stages of gestation. In this country during the 19th century, the vast majority of the states enacted statutes criminalizing abortion at all stages of pregnancy. By 1868, when the 14th Amendment was ratified, 3/4 of the states, 28 out of 37, had enacted statutes making abortion a crime even if it was performed before quickening. Of the 9 states that had not yet criminalized abortion at all stages, all but one did so by 1910. The trend in the territories that would become the last 13 states was similar. All of them criminalized abortion at all stages of pregnancy between 1850 and 1919. By the end of the 1950s, according to the Roe Court's own count, statutes in all but 4 states and the District of Columbia prohibited abortion however and whenever performed, unless done to save or preserve the life of the mother. This overwhelming consensus endured until the day Roe was decided. At that time, also by the Roe Court's own count, a substantial majority 30 states still prohibited abortion at all stages except to save the life of the mother. And though Roe discerned a trend toward liberalization in about 1/3 of the states, those states still criminalized some abortions and regulated them more stringently than Roe would allow. In short, the court's opinion in Roe itself convincingly refutes the notion that the abortion liberty is deeply rooted in the history or tradition of our people. 4. The inescapable conclusion is that a right to abortion is not deeply rooted in the nation's history and traditions. On the contrary, an unbroken tradition of prohibiting abortion on pain of criminal punishment persisted from the earliest days of the common law until 1973. The court in Roe could have said of abortion exactly what Glucksberg said of assisted suicide. Attitudes toward abortion have changed since Bracton, but our laws have consistently condemned and continue to prohibit that practice.
Respondents in their amici have no persuasive answer to this historical evidence. Neither respondents nor the Solicitor General disputes the fact that by 1868 the vast majority of states criminalized abortion at all stages of pregnancy. See brief for the petitioners, 12-13. See also brief for American Historical Association and Organization of American Historians as amicus curiae, 27-28 and notes 14-15, conceding that 26 out of 37 states prohibited abortion before quickening. Oral argument transcript 74-75, Respondents' Counsel conceding the same. Instead, respondents are forced to argue that it does not matter that some states prohibited abortion at the time Roe was decided or when the 14th Amendment was adopted. But that argument flies in the face of the standard we have applied in determining whether an asserted right that is nowhere mentioned in the Constitution is nevertheless protected by the 14th Amendment. Not only are respondents and their amici unable to show that a constitutional right to abortion was established when the 14th Amendment was adopted, but they have found no support for the existence of an abortion right that predates the latter part of the 20th century. No state constitutional provision, no statute, no judicial decision, no learned treatise. The earliest sources called to our attention are a few district court and state court decisions decided shortly before Roe and a small number of law review articles from the same time period. A few of respondents' amici muster historical arguments, but they are very weak. The Solicitor General repeats Roe's claim that it is doubtful abortion was ever firmly established as a common law crime even with respect to the destruction of a quick fetus. But as we have seen, great common law authorities like Bracton, Koch, Hale, and Blackstone all wrote that a post-quickening abortion was a crime and a serious one at that. Moreover, Hale and Blackstone, and many other authorities following them, asserted that even a pre-quickening abortion was unlawful and that, as a result, an abortionist was guilty of murder if the woman died from the attempt.
Instead of following these authorities, Roe relied largely on two articles by a pro-abortion advocate who claimed that Koch had intentionally misstated the common law because of his strong anti-abortion views. These articles have been discredited, and it has come to light that even members of Jane Roe's legal team did not regard them as serious scholarship. An internal memorandum characterized this author's work as donning the guise of impartial scholarship while advancing the proper ideological goals. Continued reliance on such scholarship is unsupportable. The Solicitor General next suggests that history supports an abortion right because the common law's failure to criminalize abortion before quickening means that at the founding and for decades thereafter, women generally could terminate a pregnancy, at least in its early stages. But the insistence on quickening was not universal, and, regardless, the fact that many states in the late 18th and early 19th century did not criminalize pre-quickening abortions does not mean that anyone thought the states lacked the authority to do so. When legislatures began to exercise that authority as the century wore on, no one, as far as we are aware, argued that the laws they enacted violated a fundamental right. That is not surprising since common law authorities had repeatedly condemned abortion and described it as an unlawful act without regard to whether it occurred before or after quickening. Another amicus brief relied upon by the respondents tries to dismiss the significance of the state criminal statutes that were in effect when the 14th Amendment was adopted by suggesting that they were enacted for illegitimate reasons. According to this account, which is based almost entirely on statements made by one prominent proponent, important motives for the laws were the fear that Catholic immigrants were having more babies than Protestants and that the availability of abortion was leading white Protestant women to shirk their maternal duties. Resort to this argument is a testament to the lack of any real historical support for the right that Roe and Casey recognized. This court has long disfavored arguments based on alleged legislative motives. The court has recognized that inquiries into legislative motives are a hazardous matter. Even when an argument about legislative motive is backed by statements made by legislators who voted for a law, we have been reluctant to attribute those motives to the legislative body as a whole. What motivates one legislator to make a speech about a statute is not necessarily what motivates scores of others to enact it. Here, the argument about legislative motive is not even based on statements by legislators, but on statements made by a few supporters of the new 19th century abortion laws, and it is quite a leap to attribute these motives to all the legislators whose votes were responsible for the enactment of those laws. Recall that at the time of the adoption of the 14th Amendment, over 3/4 of the states had adopted statutes criminalizing abortion, usually at all stages of pregnancy, and that from the early 20th century until the day Roe was handed down, every single state had such a law on its books. Are we to believe that the hundreds of lawmakers whose votes were needed to enact these laws were motivated by hostility to Catholics and women? there is ample evidence that the passage of these laws was instead spurred by a sincere belief that abortion kills a human being. Many judicial decisions from the late 19th and early 20th centuries made that point.
One may disagree with this belief, and our decision is not based on any view about when a state should regard prenatal life as having rights or legally cognizable interests, but even Roe and Casey did not question the good faith of abortion opponents. C. E. G. Casey, 505, U.S. at 850. Men and women of good conscience can disagree about the profound moral and spiritual implications of terminating a pregnancy even in its earliest stage. And we see no reason to discount the significance of the state laws in question based on these amici suggestions about legislative motive. C. 1. Instead of seriously pressing the argument that the abortion right itself has deep roots, supporters of Roe and Casey contend that the abortion right is an integral part of a broader entrenched right. Roe termed this a right to privacy for 10 U.S. at 154, and Casey described it as the freedom to make intimate and personal choices that are central to personal dignity and autonomy. Casey elaborated, at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. The court did not claim that this broadly framed right is absolute, and no such claim would be plausible. While individuals are certainly free to think and to say what they wish about existence, meaning, the universe, and the mystery of human life, they are not always free to act in accordance with those thoughts. License to act on the basis of such beliefs may correspond to one of the many understandings of liberty, but it is certainly not ordered liberty. Ordered liberty sets limits and defines the boundary between competing interests. Roe and Casey each struck a particular balance between the interests of a woman who wants an abortion and the interests of what they termed potential life. But the people of the various states may evaluate those interests differently. In some states, voters may believe that the abortion right should be even more extensive than the right that Roe and Casey recognized. Voters in other states may wish to impose tight restrictions based on their belief that abortion destroys an unborn human being. Mississippi Code Annotated, Section 41-41-191, 4b. Our nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. Nor does the right to obtain an abortion have a sound basis in precedent. Casey relied on cases involving the right to marry a person of a different race, Loving v. Virginia, 388, U.S. 1, 1967, the right to marry while in prison, Turner v. Safley, 482, U.S. 78, 1987, the right to obtain contraceptives, Griswold v. Connecticut, 381, U.S. 479, 1965, Eisenstadt v. Baird, 405, U.S. 438, 1972, Carey v. Population Services International, 431, U.S. 678, 1977, the right to reside with relatives, Moore v. East Cleveland, 431, U.S. 494, 1977. The right to make decisions about the education of one's children, Pierce v. Society of Sisters, 268, U.S. 510, 1925. Meyer v. Nebraska, 262, U.S. 390, 1923, the right not to be sterilized without consent, Skinner v. Oklahoma ex rel. Williamson, 316, U.S. 535, 1942, and the right in certain circumstances not to undergo involuntary surgery, forced administration of drugs, or other substantially similar procedures. Winston v. Lee, 470 U.S. 753, 1985. Washington v. Harper, 494 U.S. 210, 1990. Rochin v. California, 342 U.S. 165, 1952. Respondents and the Solicitor General also rely on post-Casey decisions like Lawrence v. Texas, 539 U.S. 558, 2003, right to engage in private, consensual sexual acts, and Obergefell v. Hodges, 576 U.S. 644, 2015, right to marry a person of the same sex. These attempts to justify abortion through appeals to a broader right to autonomy and to define one's concept of existence prove too much. Casey, 505, U.S. at 851. Those criteria, at a high level of generality, could license fundamental rights to illicit drug use, prostitution, and the like. None of these rights has any claim to being deeply rooted in history. What sharply distinguishes the abortion right from the rights recognized in the cases on which Roe and Casey rely is something that both those decisions acknowledged. Abortion destroys what those decisions call potential life and what the law at issue in this case regards as the life of an unborn human being. See Roe, 410 U.S. at 159, abortion is inherently different. Casey, 505 U.S. at 852, abortion is a unique act. None of the other decisions cited by Roe and Casey involve the critical moral question posed by abortion. They are therefore inapposite. They do not support the right to obtain an abortion, and by the same token, our conclusion that the Constitution does not confer such a right does not undermine them in any way.
Part 3.
American Apologetic. A perusal of Dobbs v. Jackson. Leaked abortion case. Written and produced by Pacificatoris.
To be continued.